Well, we're not having illumination at the background. Okay, okay, it's coming up now. Okay. All right. Good evening, gentlemen. Okay. Right. So we are going to look into one of the assignments that we get to a particular group, that stubborn group that has refused to do their work. So, like, has he sent it to you? Let me just look at the topic because I've gone through all the assignments you submitted. There's nothing submitted with respect to this topic. And it's supposed to be group 8. You're supposed to discuss interpleader proceedings. So members of group 8, I'm not happy with you because you didn't do your work. And I think there will be a little sanction for that. So course rep, you need to give me the list of all the members of group 8. So we can't just take our lectures for granted. All right. Having said that, so I'll just go ahead and give us the tips on that very topic, interpleader proceedings, interpleader. Now, we all know what pleading means. When somebody says plead, we understand that word plead. Plead means to beg, to pray, to ask for a favor, to make a request. So that is what that word plead stands for. And in the legal parlance, we have something called interpleader. Why the word interpleader is because the pleading here is not necessarily being made by the actual parties to the action, but it is a plea, a request, a demand that is being made by a third party for some specific reasons, which we are going to look into for proper understanding of it. So in law, when we talk about interpleader, interpleader simply means a procedure whereby a person who is faced with competing interests with respect to a property in his custody. That property may be money, it may be money worth, it may be any other proprietary interest in his custody, but there are other people that are claiming ownership of what is in his possession, ownership of what is in his custody. And because he does not want to make mistakes, like giving it to Mr. A, where in the end, Mr. B will turn out to be the actual owner of the property. And you know, if he makes the mistake of giving the property to Mr. A instead of Mr. B, you will face litigations. You will have the problem of having to replace whatever he has given away to Mr. B, to Mr. A, sorry, especially if Mr. A happens to be a fraudulent character. So that's why we say that in an interpleader proceeding is a proceeding recognized by the court whereby a person known as the stakeholder who is in the custody of property or chattel wants the court to determine between competing interests who among the competing interests is actual owner of the property in his custody. So by so doing, he will escape liabilities. He will not be held liable for giving to Mr. Jacob what ought to have been given to Mr. Joe. So that's what we call interpleading or interpleader proceedings in law. Now, interpleader proceedings in law are of two species, but before discussing the different species, I want us to look at how the court defined interpleader proceedings in a decided case. It's a very old case. That's the case of Chief VC Obumseli. Chief VC Obumseli. Obumseli. And another against Chinyelugo P. Owakwe. Chinyelugo P. Owakwe. That case you can find reported in 2019 Law Pavilion, that is LPELR 46937, Supreme Court. Is a Supreme Court decision. In this very case, the Supreme Court was faced with an instance of Interpleader, where an interpleader has brought an application. I will also give us the facts much later, but let's look at the definition given by the Supreme Court when we talk about interpleader. The Supreme Court said that interpleader is a proceeding by which a person who does not himself claim ownership of the property can protect himself. Mind that word protection, because we're going to talk about it. He can protect himself from legal proceedings by calling upon the claimants to interplead, that is, claim against each other, so that the title to the property or the debt may be finally determined by the court. Now let's take this definition in pieces as it appears here. A person is in custody of what does not belong to him. And this person who is in custody of what does not belong to him is not claiming ownership of this very property. He knows that the ownership of this property does not reside in him, but he needs to protect himself. Why do we use the word protection? He needs to protect himself in that he does not want to be wrong. He does not want to give this property to a wrong person, in which case he will be asked to pay or to go and retrieve it. And maybe the process of retrieving the property to give to the right owner may be successful or it may not be successful, but in the end, it must cause some inconveniences to him. So that is why he has to protect himself. By protecting himself, what does he do? He can sue Mr. A and Mr. B as defendants claimant, but himself is the stakeholder claimant. I will explain all those terms. Because he is the person who has this property in his hand, and he is the one seeking for the court's intervention by the virtue of the fact that he is the one that is moving the court to take an action. He is the claimant. So he is right to call himself a claimant or a stakeholder claimant or a stakeholder. And then he brings in the two competing persons who have been disturbing him over this property. Possibly himself doesn't know who to give the property to. He doesn't know the actual owner between A and B. So in order to protect himself, he drags them to court and asks them to interplead. What's the meaning of interplead in that respect? Show proof that you are the owner of this property. Mr. B, also show proof that you are the owner of this property. Why? Because we say that in law, the law knows no jus party. So you cannot just claim because I think it should be this person and then you take what belongs to A and give to B. No. You must take care, you must take precaution to ensure that you do not fall into that very trap that may cost you heavily in the end. And that's why the stakeholder is dragging these two possible claimants to this property in his custody to come and interplead. Let them come and show cause. Let them prove, show, establish how this property belongs to any of them. Now, what happened in this very case? This case now is not particularly a case on stakeholder interpleader. So I will still come back to this case again. Now, when an interpleader, this third party who is in custody of property and wants the court to determine who the actual owner is, once he comes to the court and makes undertaking, my lord, I'm surrendering the property. If my lord decides that it belongs to A takes it. So he can still be in possession depending on what the court orders. The court may still order him depending on the nature of the goods, especially if the goods is a perishable one. You can keep the property pending the determination of this claim. If A wins, then this our friend, the stakeholder, will now transfer the property to A. And mind you, nothing stops the court from making the real owner to bear the cost of action undertaken by the stakeholder. Why? Because the stakeholder has expended his time, he has expended his money trying to ensure that peace reigns, that the title should be determined so that the owner of the property will take it. That's one way of preserving the property. Another way is when the stakeholder brings his interpleader proceedings, the court may make orders that the property may be deposited within the registry of the court. Assuming it's money, the court may order the registrar of the court to open an escrow account wherein the money will be paid. It could be an interest yielding account, so that in the end, whoever wins the matter will take the money from that place. And if there is any compensation or cost which the court will deem fit to make in the circumstance of the case, the court can also make it. Why? Because this person who has initiated the interpleader proceedings must be seen as somebody who is acting out of good faith. He is somebody who is saying, look, I'm holding something that does not belong to me, but I want the real owner to take over this very property. So it's an action that should be commended, and he is a character that also should be appreciated for what he has done. Now we'll talk about types of interpleader proceedings. I have already stated one. The first one I talked about now is the stakeholder interpleader proceeding. The stakeholder simply means if I'm holding property which belongs to some competing interests and I don't know who actually is the owner, or I don't want to make mistakes, I will now say, okay, let me go to court. Let me drag this people to court. Let them go and prove their case. Whoever wins takes it. In a time, somebody will ask, is it possible for somebody to be in possession or in custody of property belonging to somebody he doesn't know who the real owner is? The answer is yes, it happens. I'll give you very simple examples. Let's say, for instance, A is a tenant to Mr. B. He pays rent to Mr. B as his landlord. Unfortunately, in course of time, Mr. B dies, and Mr. B maybe has a lot of wives. He had a lot of children, and each day, Mr. X, Mr. Y, Mr. Z comes to trouble these tenants. I'm the one entitled to rent. Pay me rent, pay me. And this person does not know who to pay the rent to. In that case, he can interplead. He can sue them and then also claim for the cost of his action. Let the court determine, let them go and prove to the court who among them is entitled to collect rent, so that he doesn't end up paying rent to widow A and then face a legal action by widow B. So that's one of the ways whereby this stakeholder interpreting proceeding may arise. It may also arise where you have maybe people who are doing joint business. I'll give you two examples now. Let me say like husband and wife or a boyfriend and girlfriend combining resources to trade, and they have a customer. The customer goes there, buys on credit, sells and returns the money. So he doesn't care which of them he gives the money to because he doesn't know the quantum of interest of each of them. But let's also say that, let's assume that at a particular instance, this customer bought goods on credit. But before you could return the money, the boyfriend and girlfriend separated, they had issues. And the boyfriend comes, my friend, give me my money. The girlfriend comes, my friend, give me my money. Or the husband has started having problem with the wife, possibly they have divorced, and each of them is troubling this customer. Bring the money you are owing me. And as far as this customer is concerned, two people sold the goods to him. He is indebted to two people. And now they are coming severally to demand for payment. And he wants to play safe as a stakeholder. What does he do? He initiates interpleader proceedings. And these interpleader proceedings let either the boyfriend or the girlfriend prove that he or she is the actual person entitled to have this money paid to him or her, or the husband or the wife. So that is how the stakeholder interpleader operates. It can also happen where you have a classical case of partnership that eventually collapsed, and the customer or somebody who is owing that partnership firm does not know who to pay the money to. He can actually initiate interpleader proceedings so that the court will determine of the claimants who actually is entitled to have the money. In which case, once it is resolved, he is discharged from liabilities. There's another way whereby this person can be discharged from liability, and that can happen where if the court orders him to deposit the money in an interest-hidden account or bring the property to the court or give it to the registrar of the court. Once that is done, he is discharged. So the other people will go ahead with their litigation. So there won't be any need subjecting this stakeholder to coming to court, spending his money, being in the process of trial until the trial is over and the matter finally determined. No, he can be discharged at any time subject to the convenience of the court. So we've talked about the stakeholder interpleading now. So the next type of interpleader or interpleader proceeding I want to talk about is the sheriff. The sheriff interpleading proceeding or the sheriff interpleader proceeding. Now, when we talk about the sheriff interpleader proceedings, this is actually something that has resulted from execution of a judgment of a court. How does this happen? Let's assume that A has sued B and B won the case, and there are some orders made in the judgment which are executory in nature. Let's say, for instance, the judgment has asked A to pay B the sum of 10 million naira, either forthwith or within a given period of time. Now, if at the time of execution of judgment, this money has not been paid, B can call the instrument of the court for the judgment of the court to be levied against every property, every movable property owned by Mr. A. Let's assume that Mr. A has a luxurious car, and then the judgment, the execution of judgment attaches on the car. The vehicle will now be moved to the court premises. So if the vehicle is moved to the court premises and eventually sold, the money will be given to the judgment creditor. Right. I will still talk more on this by the time I talk about execution of judgment and judgment of court. But let's assume that when the judgment of the court was levied, Mr. A was not the owner of that vehicle that was taken in execution, that was destroyed. And maybe that vehicle belonged to Mr. Z. As soon as Mr. Z realizes that his vehicle has been mistakenly taken in execution of a judgment of a court, he applies to the registrar of the court, we call the sheriff of the court. He makes an application to the court, file his affidavit, satisfying the court as to how this vehicle belongs to him. Of course, you know the things that may be required of him to do. Bring your purchase receipt, if any, vehicle particulars, if any other facts that will help the court to know or to believe you that this vehicle belongs to you and that it does not belong to the judgment debtor. So when those evidence, those facts are exhibited in the affidavit and submitted to the court, it becomes the duty of the sheriff, or let's just say the court officer in charge. It can be the court admin, it can be the chief registrar. It now becomes the duty of this very sheriff to initiate what is called interpleader summons. In interpleader summons, what it's going to do is simply to record the parties that have litigated and judgment was given, and he will simply add the name of this claimant as the person who is interpleading, this third party interpleader. So the parties will appear before the court to hear the case of this person who is saying the property belongs to me. Naturally, most of the times, if the property does not belong to the judgment debtor may have nothing to urge on the court. But the judgment creditor is the one that may struggle to say, no, this vehicle belongs to this person. There is fraud. Of course, we cannot rule out the possibility of forgery. We cannot rule out the possibility of collusion. But then the issue is, can you prove it? So if it is possible for the judgment creditor to prove that this property, this car, actually belong to the judgment debtor and not the interpleader, then the action, that interpleader summons action proceedings will be terminated and will be determined against that third party, and that vehicle will remain destroyed as a process that has been taken over during execution of judgment of the court. But if maybe the third party affidavit is strong enough and the judgment creditor does not have facts to impeach, challenge, or debunk the factual arguments contained in that affidavit of this interpleader, well, he doesn't lose much. All he needs to do is to do what? To still pursue against the judgment debtor. That is exactly what happened in that case that I cited. In that very case, somebody was indebted. There was a judgment. There was a judgment debt. That was a judgment given against a particular judgment debtor. But before the execution could be concluded, the judgment debtor died. So when he died, the judgment creditor levied the execution on a vehicle found in the family compound. So the mother of the deceased, that the deceased judgment debtor, filed an affidavit in the court stating facts that the vehicle belonged to her and not the late son. So she was able to show credible evidence that that vehicle belonged to her. There are a lot of issues that were involved in that very case. The judgment creditor contended in the first instance that the issue of sheriff interpleader is not something that will be decided based only on affidavit evidence. That was one of the issues contended. The second issue contended was that the sheriff ought to be a party to that very proceedings. And then thirdly, the judgment creditor could not challenge effectively all the factual arguments of the mother of the deceased judgment debtor. Now the court resolved for failing to file a counter affidavit to challenge the factual arguments of the mother of the deceased judgment debtor, it means that the evidence of that woman was unchallenged. So the court released the vehicle to the lady. Secondly, on the issue of whether interpleader proceedings can be determined by way of affidavit evidence, the court said yes. If the affidavit evidence is unchallenged, judgment can be given based on that. That is, the court can give its ruling in favor of the interpleader. But if, on the other hand, the judgment creditor has effectively filed a counter affidavit countering most of those things, and the judge believes that there is or there are some conflicts to be resolved and enter into the witness box, then do a sort of mini trial to show whether the interpreter is saying the truth or whether he is lying. And then the third issue, the court resolved that a sheriff, being the initiator of the process, is a proper party in a sheriff interpleader proceedings. But there is nothing wrong if the name of the sheriff or the office of the sheriff is not added in the interpleader proceedings, so long as the judge signs that interpleader proceedings initiated by the sheriff. Because all those things, the court just simply look at them as mere technicalities. That the main thing to decide there is the merit of the matter, to find out whether somebody's property has been wrongly destroyed or has been rightly destroyed. Now again, we have to know that a sheriff, being an officer of the court, has immunity so far as he works within the scope of his authority. If he leaves the scope of his authority and he goes on a frolic of his own, then he will be liable. That is when it said that a sheriff can be liable for wrongful execution of judgment. In other words, it's just like a caveat. Let the sheriff beware. Before you levy execution, make sure that you make some findings to be sure that this property you are levy taking in execution actually belongs to the judgment debtor. And how does the sheriff do this in practice? There has to be an inventory. He takes an inventory of the properties, and while taking the inventory, the judgment debtor can say, this is not my own. And the sheriff will pick it and say, okay, no problem. Who has it? He can tell you it's Mr. So, but if you cannot substantiate it as at that point in time, the sheriff will be acting within reasonable limits to destroy that property. Because you can have instances where judgment debtor may simply be telling lies. But in the absence of that, where it is obvious that property destroyed does not belong to the judgment debtor, then the sheriff could be liable for wrongful levying of execution. And then again, there may be instances where property mortgage to someone else, mortgage to the mortgagee, becomes a subject or is levied in execution, taken while execution is being levied. When a situation like that arises and the mortgagee has interest in that matter, what the court will normally do is to look at the circumstances of the case and ask itself, what will be the justice of this matter? In good number of cases, the court can act under the extant provisions of the judgment enforcement procedure rules to order that that property be sold, and then the proceeds of that property disbursed accordingly, depending on the facts of the case presented before the court. So far so good. This is all we have to take home today as standing for interpleader proceedings. Summing it up, two types of interpleader proceedings: the stakeholder interpleader proceeding and the sheriff interpleader proceeding. Get to also know the differences between two of them. The other one is more or less official. The stakeholder is a personal something. Somebody who is trying to escape liability drags the claimants to court for the court to determine the real owner so as for himself to escape liability of litigation or having been made to retribute what actually has been wrongly distributed to a wrong person. And then talking about the sheriff interpreter, that one is purely official. It's something that happens within the scope of the judiciary when a judgment is already delivered against somebody and the sheriffs are in town to levy execution on the properties of the judgment debtor. At that very moment, anybody whose property is in the premises of the judgment debtor has to speak out, apply to the court, and tell the court what your property was doing in the premises of the judgment debtor. Maybe he's your friend, he borrowed your car, or you normally park your vehicle there. Whatever it is, you must be able to provide reasonable and satisfactory materials by way of your affidavit evidence to prove to the court that actually that property does not belong to the judgment debtor, but that the property belongs to you. So far so good. We have come to the end of today's lecture. So we fix further lectures so that we'll continue to see how we can round off all the topics we have lined up for the semester. Thank you. Do have a nice day.